Thank you very much, Karabo, and thank you very much to all of you who've come out today on the Saturday to come and listen to what we have to say about this very important issue. Ladies and gentlemen, 7 months ago, South Africans were imbued with a sense of great hope and optimism when the African National Congress and the Democratic Alliance came to an agreement and signed a statement of intent to herald a new era of government in South Africa, a government based on coalition, a government based on power sharing. The statement of intent was the document and the basis upon which we gave our support to President Cyril Ramaphosa and voted him into office as the President of the Republic of South Africa on the 14th of June 2024. It was also the basis upon which we entered government in order to keep out the destructive policies of the MK party and the economic freedom fighters, and to contribute to building a better South Africa, a better future, and a better life for all South Africans. This came about after the voters and the people of the Republic of South Africa voiced their dismay with the ANC over their chronic service delivery failures, over the corruption, and over the missteps in government. In doing so, the voters of South Africa deprived the ANC of a majority for the first time in 30 years. Through their votes, the people of South Africa indicated that they wanted parties to work together to build a better South Africa. And I think this point is one which is absolutely worth emphasizing, that this is not a project of politicians. It is an expression of the will of the people of South Africa, who clearly said that they wanted parties to work together in a mutually respectful way to build South Africa and to ensure their interests were advanced. I'm proud to say that the DA continues to uphold our side of the bargain of that statement of intent. Portfolios that are under the control of DA ministers have done more to deliver progress in those ministries in the last 7 months than we've seen the ANC achieve in the last 30 years. Every single day, DA ministers, DA deputy ministers, presiding officers in Parliament, House chairpersons in the NCOP, and committee chairs get out of bed more determined than ever before to build a more inclusive, prosperous, and free South Africa. That is why we are in government, and that is what we are delivering. And this is precisely because we have heard the cry of the people for constructive cooperation, that the DA treats our fellow coalition partners and colleagues from other parties in a 10-party GNU with respect, making constructive suggestions aimed at resolving disagreements rather than inflaming them. As a result of all of this, the green shoots have started appearing in our economy and in the employment statistics. The rand has strengthened, and international analysts have hailed the formation of the GNU as South Africa's most significant moment since 1994. The recent World Economic Forum in Davos, from which I've returned from this morning, reflected the positive attitude of the world towards this magnificent political development. Every day since June 14 last year, the Democratic Alliance has made a concerted effort to ensure the success of the GNU. We have negotiated, we've compromised where needed, because as veterans of coalition politics, we know that no matter how large you are in a coalition, you don't always get your own way. You don't have 50% of the vote, which means that you cannot get everything that you want. At the same time, however, in various press conferences, we have made it abundantly clear that we were in government, in this GNU, to share power, not merely to make up the numbers, for the ANC to continue rolling out the same destructive policies and and proposals that have landed South Africa in the situation that it has found itself over the last 2 decades. Now, any coalition agreement is premised on the acknowledgement that the larger party will, of course, have to be prepared to negotiate and compromise where needed, because all parties in the government of national unity represent the interests of a minority. However, after a very promising start whereby President Ramaphosa delayed the implementation of the Basic Education Laws Amendment Act to enable negotiations to continue, recent weeks have made it increasingly clear that the ANC has lost interest in honouring its side of our relationship and statement of intent. Unfortunately, the ANC has taken to openly disrespecting coalition partners and undermining the very trust upon which a coalition agreement is built. In his statement at the January 8th anniversary, President Ramaphosa was quoted as saying that although the ANC failed to secure 50% plus 1 in the elections, the ANC is still in charge. Just today, the President opened the ANC's Lekgotla by saying that the GNU exists to implement the NDR, the National Democratic Revolution. Now, not only is a statement like this incorrect, it is immature, but it also does not accord to the letter and spirit of the statement of intent. Unfortunately, however, it does accord with behavior of recent weeks. In the last week, the President not only disregarded the very serious constitutional objections raised by the Minister of Public Works and Infrastructure, Minister Dean McPherson, over the Expropriation Bill, but he failed to even have the courtesy to inform the Minister about when he intended to sign the bill into force. Similarly, a few weeks ago, I personally wrote to the President about the contentious National Health Insurance Act, which, despite the fact that it was raised very clearly in the negotiations going into the agreement, despite the fact that there was agreement by all parties that there would be continued negotiations about it, we're met with TV screens at airports rolling out that the NHI is here. That does not accord to the spirit and intent of negotiation, compromise, and cooperation. In the correspondence that I addressed to the President, I made a number of constructive proposals for consideration because, as a democratic alliance, we want universal access to basic health care for all South Africans, regardless of their income. However, the NHI in its current form, which seeks to destroy private medical aids and tax credits and to launch an assault on the private medical sector, is not the way to go. If anything, Operation Vulindlela has shown us over the last few years it is indeed a public-private partnership and cooperation that leads to greater successes in government. I made a number of these constructive proposals which set out very clearly our position on the matter, and I asked for a meeting with the President to further engage ahead of the upcoming Cabinet Lekgotla to prevent a repeat of the events from the previous Lekgotla, where we vehemently objected to the inclusion of the NHI targets in the documentation. Amazingly, the President refused to even meet with the leader of the largest party in the coalition to discuss the single most critical issue for the future of the GNU and for the future of South Africa. Instead, my letter was simply waved away and sent into the abyss of the health department. And that leads me to the next point, because the same place my letter was sent to has been met with a really odd response. Instead of engaging respectfully and maturely to find solutions, the ANC Minister of Health, Aaron Motsoaledi, declared war on the GNU in front of the world at Davos this week. Motsoaledi told world leaders assembled at the World Economic Forum that he is fighting what he called a war against the people of South Africa who don't want their private medical aids expropriated and who don't want higher taxes to fund a new looting scheme and who don't want to see our healthcare system in South Africa destroyed. This is not how mature colleagues behave, that is not how you negotiate, and that is not how you compromise. It is arrogant, and it is deeply disrespectful, not only to the Democratic Alliance, but to the other parties, to the Government of National Unity, who have also expressed their concerns about the NHI, and who are also patiently waiting for a negotiation around this particular matter. It is a symptom of a continued lack of respect accorded to coalition partners, as well as to the founding agreement. And most importantly, from international experience and local experience, this is not how healthy coalitions work. Whether the ANC likes it or not, the stability of this government, as well as the security of the President's own position, depends entirely on the relationship between the two largest parties to the Government of National Unity. In keeping with our mature approach to coalition government, the Democratic Alliance is therefore urgently seeking to pursue a reset in this relationship. To do so, I yesterday wrote directly to President Ramaphosa to do the following things: to object in the strongest possible terms to the fact that he simply signed the Expropriation Act this week in contravention of a clear legal opinion and concerns submitted by the Minister of Public Works that the Act is in fact unconstitutional and could quite easily be remedied by sending it back to Parliament. Secondly, to note the DA's implacable opposition to the inclusion of the NHI, and particularly the proposals to start to move to eliminate private medical aid and the continued assault on the private healthcare sector in South Africa contained in the documentation of the Medium-Term Development Plan, with, of course, the accompanying budgetary implications of this. Bear in mind again, we are in government to see economic growth and job creation and an end to poverty in South Africa. Every policy, every law, every initiative by government should be measured through the lens of the following things. Will this help grow the economy? Will it create jobs? And will it help lift more South Africans out of poverty? And finally, to record the failure to set up of now an effective dispute resolution mechanism, as well as the clear abuse of the clearinghouse mechanism, which still does not have adopted terms of reference going forward. But most importantly, I notified the President that I was now invoking Section 19 of the Statement of Intent. Clause 19 was specifically put in place to deal with situations where disagreements within the coalition arose. Clause 19 codifies the procedure to be followed when differences arise between parties to the Government of National Unity. Clause 19.3 states, and I quote, "Sufficient consensus exists when parties to the GNU representing 60% of seats in the National Assembly agree," unquote. The only parties that represent 60% of the seats in the National Assembly are the African National Congress and the Democratic Alliance. In the event of a lack of sufficient consensus, the Statement of Intent in Clause 20 continues, "The parties to the GNU shall also establish dispute resolution or deadlock breaking mechanisms in instances where sufficient consensus is not reached." The President needs to accept, along with his party, that the ANC does not have a majority in South Africa. They are now just another minority party, and that the DA are partners in the GNU. We won over 3.5 million votes in the last election, and we are in government to represent our voters and to rescue South Africa by growing the economy and creating jobs and ending poverty. If we cannot fulfill this mandate within the GNU and are treated merely as a doormat or treated as simply there to make up the numbers, we have to seriously consider our next steps. The DA, and I want to be very clear about this, the DA will not be reduced to being mere spectators in a government of which we bring a large part of the seats. I want the people of South Africa to know that the DA does not take this step lightly. We understand the grave implications, not only for politics, but for the future of governance in South Africa. The seriousness of this situation demands that we do engage other parties in the GNU too, who, like us, have publicly come out against the acts of the recent week, and particularly the IFP, who have now come out very strongly against the Expropriation Act too. We are invoking Clause 19 in pursuit of an urgent reset in the relations, because South Africa deserves a functioning coalition where partners treat each other with respect in pursuit of the solutions to the country's many pressing problems. The solutions must work to undo the failed policies of the past 30 years and set South Africa sailing on a new path of hope, prosperity, and opportunity for more South Africans. It is also not good enough to stand on the world stage and take the bouquets for the formation of the GNU if you are unwilling to domestically put in the hard yards that are required to make coalitions work. Under the GNU now, it is time for a reset that treats all parties to the GNU as key players in the decision-making processes of this government and the policies and practices that it will pursue. It is also a time for new policies and for a new direction for South Africa, away from the failed policies of the past, and that is precisely why the GNU was met with so much hope and excitement. And it's that hope and excitement that we wish to give a greater opportunity to through a reset in these relations. If the reset is not possible, and we remain unable to be able to play our part in the growth and jobs agenda, if our ideas, if our solutions are merely waved away with the hand of the national democratic revolution, then we too will have to reconsider our options and how to best serve South Africa in this situation. It is my fervent hope that the coming week will see a coming together of the ANC and the DA, as well as the leaders of other parties, to adopt a far more cohesive, collaborative partnership towards governing South Africa and to implementing a new policy agenda that will bring the jobs we need, that will grow the economy in the way we need it to grow, and which will lift millions of our citizens out of poverty and into a new era of hope, opportunity, and prosperity. Thank you very much.
Thank you very much, John. Colleagues, I'm now going to hand over to Dean McPherson, who's going to give us politically an overview of himself as a DA cabinet member whose department is now responsible for overseeing the Expropriation Act and how that affects South Africans and where we stand with that as the Democratic Alliance. Dean, I'm going to hand over to you now.
Thank you very much, Karabo, and to John, our leader, and colleagues here. Let me start off by saying that I am in government at the behest of my party, the Democratic Alliance, and I'm here to serve the interests of my party and the 3.5 million voters that sent us into government, and to serve the broader interests of the public. And one of my priorities is to always ensure that the Constitution is upheld, respected, and implemented. And so it was that in mind, and with my oath of office that I took to be a faithful counsellor to the President, I embarked on a consultation with his office regarding the Expropriation Bill then, to ensure that I was satisfied with the advice that he may have received in the 6th administration, and to ensure that my office was on the same page in terms of its legality or constitutionality. With that in mind, on the 5th of December, I provided the President with a comprehensive legal opinion by one of South Africa's foremost senior counsels in public law, which outlined a fatal constitutional problem with the then bill. I suggested to the President, in terms of my counsel, that he should refer the then bill back to Parliament in terms of Section 79(1) of the Constitution to ensure that those issues and those fatal defects in the bill were rectified. On the 21st of January, I received a letter from the President to simply say that after careful consideration, the bill meets constitutional muster. 2 days later, via a social media post, I became aware that the bill had in fact been assented to. That was the first time I became aware of it. It was the first time that the leader of my party became aware of it, and the partner of the second largest party in the government of national unity. What is clear, however, is that individuals with my department were either tipped off or made aware that the bill was going to be assented to, because there was a press release ready that was not authorized by myself or my office, which in fact completely contradicted the President's own press statement, spoke about greedy landlords, spoke about evicting people, farm workers being able to claim land, talking about taking land from people, and so on. There were also a number of graphics that had also been prepared. Now, never in the history of government has anyone other than the Minister responsible for legislation communicated on that particular piece of legislation. So it was incredibly unfortunate and regrettable that myself, as the Minister who had taken the opportunity to counsel the President in terms of my oath of office, was not taken into confidence that the bill would be signed or assented to, but other people were. That being said, it's important that I highlight what was found to be unconstitutional with the bill. And I'll take you through the points as in a lay process as best as I can. But if effectively there is a contradiction in the sequencing of how expropriation is supposed to take place between Section 7, 8, and 19. Section 19 envisages that where the expropriating authority and owner do not agree, that the amount of compensation to be paid, that there is a process to take place. That firstly, the parties must attempt to settle the dispute by mediation. If they are unable to settle the dispute by mediation, either party may, within 180 days of the date of the notice of expropriation, institute proceedings for a court to decide or approve the amount of just and equitable compensation. So either parties can follow that process. The disputing party may, within 90 days of the date of the notice, request the expropriating authority to institute such proceedings. So the authority, the expropriating authority or the government, would have to go to court to get the court to determine just and equitable compensation. It's clear from these provisions that the envisaged process to determine the amount of compensation must be instituted within 180 days, but Sections 7 and 8 require that by the time notice of expropriation is issued and served, the amount of compensation must already have been determined, and that the court process to approve or to determine the amount referred to in Section 19 is that contemplated by Section 8. Effectively, once that amount has been determined in terms of the 7 and 8 process, the individual who is affected must then go to court and go through the court process, which severely disadvantages them. It's very clear that both processes can't exist, that they are irreconcilable with an internal conflict between the provisions of 7 and 8 on the one hand and the provisions of Section 19 on the other hand. Let me put it differently, if I may. On the one hand, the amount of compensation must be finally determined before a decision to expropriate is made and a notice of expropriation is served. On the other hand, any court proceedings to decide or approve the amount of compensation, properly interpreted, may be made only after the notice of expropriation has served. It's quite clear then that the conflicting provisions are irreconcilable with each other and are thus unworkable, rendering the Expropriation Bill and Act irrational, vague, and unconstitutional. The Expropriation Bill, just for that reason, is unconstitutional. The unconstitutionality that has been identified is on a range of levels, lead to other constitutional concerns that were previously identified in legal opinions provided to Parliament. So, these are just some of the examples of the constitutional problems in this Act, which could arise after any amendment of the bill to Parliament to cure the constitutional defect, which is why we suggested to the President that in terms of Section 79(1), that issue is confined and dealt with. And it was on that basis that I advised the President that the bill is unconstitutional. Ladies and gentlemen, that is not a matter of interpretation, but it is a matter of fact. You cannot have two contradictory processes to determine expropriation contained in one bill. It can only be one or the other. Now, I think it's important to also state that, as I said, I wasn't made aware of what these outcomes were. We had a plan to rectify it and to fix it. It was easily done. That the leader of the Democratic Alliance has now declared a dispute in terms of Section 19.3 of the Statement of Intent, and that must now be decided on the way forward. What I will say is that I think that legislation is far too important to be dealt with through acts of bad faith. I think that we cannot have situations where what happened this week becomes a norm or allowed to happen. We are partners. We are equal partners. And equal partners need to treat each other with respect and mutual respect. It cannot be that we have our own colleagues that seek to undermine, bomb the ship, and attempt to claim political mileage through these processes. That is why it was important that I went publicly and said that I will respect the foundations of the Constitution, that private property that the rights for any South African to own private property and for that property to be guaranteed will be non-negotiable for myself in terms of Section 25 of the Constitution. It is non-negotiable. And I'm not sure why so many people are angry by that, because they either don't believe or respect Section 25 of the Constitution, or they actually believe that the Expropriation Act is a foreground to land grabs, which is what some in the ANC have tried to paint this as, in order to try and find favor with voters in the MKP or the EFF that they lost. And interestingly, even they have rejected that act. So whatever they're trying to do publicly is not working. So I will leave it there, Karabo and Vili, and obviously happy to take any further questions. And I hope that that does provide some background as to how we arrived in today's situation. Thank you.
Thank you very much, Dean. Now, colleagues, I'm going to hand over to my co-pilot, Vili Okamp, who's going to facilitate our Q&A session, and he'll explain to you how we're going to do that. Vili?
Thank you, Karabo. Thank you for everybody for being here today. We really appreciate the outcome. We are going to take questions to both John and Dean. You will direct the questions to me. I think we will take 3 at a time. We'll see how many questions there are, and then offer the opportunity for those questions to be answered. I would like you to please just state the name from the news, your own name, as well as the name of the news outlet that you represent, and also to whom you direct your question. I will then decide whether we must get somebody else to answer that question, but if you can do those things, your name, your news outlet, as well as the person that you are directing your question to. Let's start there at the back.
Good afternoon, Paul Becchiato from Bloomberg. John, is the DA delivering an ultimatum to the ANC and President Ramaphosa? If so, are you going to give them a timeline and a date in which to reset, by which the GNU has to be reset? Thank you.
Thank you, Paul. I've got you in front.
Just 3 quick questions for clarity. Number one, Sine from Daily Maverick. 3 quick questions of clarity. The first one, the DA announced that they would draw up legal papers. Has these been filed, and at which court? The second one, the IFP has also opposed the Expropriation Bill. In their statement, they have said that they will take this to the GNU clearinghouse. Was this a consideration of yours, and will you be doing that? And then to Minister McPherson, you talk about individuals within your department. Please just clarify, are you talking about your Deputy Minister?
Thank you very much.
Hi, Leanne Jansen from Heart FM. To John, firstly, if your demands are not met, could this spell the end of the GNU or the DA's withdrawal from the GNU? And to Dean, the Expropriation Act or bill before, as I understand it, clauses 7 and 8 is when an amount is agreed to by the expropriating authority, and those who it's being expropriated from, and 19 then goes to the courts when no amount is being agreed to. Did your legal opinion find something different?
Right, thank you very much. There are 3 people that asked questions, but there are more than 3 questions. So, John is asking whether the Daily Maverick can just repeat what was directed to himself.
The first 2 questions around the GNU clearinghouse and then the court act.
Okay. Right, I'm going to ask John then to first reply to Paul and to Sinead as well as Leanne, and then I'll give Dean his chance as well.
Great. Thank you very much, and thank you for the question, Paul. Let me be very clear. This isn't an ultimatum. It is a call, a mature call, as a partner in the government of national unity for a reset in the relations, where we are respected and treated as partners in this government of national unity and not as spectators. And it doesn't matter whether it's foreign policy, it doesn't matter whether it is government policy, and it shouldn't matter if it's regulations. This administration is not a continuation of the 6th administration. The 6th administration was an administration led by an ANC majority government. This administration is now part of a government of national unity. And therefore, to expect us, as a new administration, to come in, to simply slipstream into everything that the 6th administration did, is fanciful and is simply not based in the realities of how government changes work. What is the whole point of an election where citizens vote to change their government, and that new government is then expected just to carry on implementing the policies of the previous government? The people of South Africa in this last election chose change, and they behoved us as political parties to work constructively together in partnership to be able to do right by them and do right by South Africa. And it was that basis that we walked in. So this isn't an ultimatum. Partners don't give each other ultimatums. But this is a very clear call for a mature reset in the relationships within the Government of National Unity, so that all of us can feel part of the decision-making and feel heard. And I want to be clear, I don't have 50% plus one in the coalition. And I've made it very clear to my own party that we will not get everything we want. And we have been prepared to compromise on many instances already within the GNU, and we're prepared to compromise going forward. But compromise cannot be borne by one party or one set of parties alone. The burden of compromise must rest with all parties in a coalition. And so there is no natural deadline and no natural ultimatum. However, I would say this. A medium-term development plan needs to be passed. A budget needs to be passed a little bit later this year. And if the Democratic Alliance is not satisfied that we have been included and our voice has been heard, those will be the backstops that I imagine would exist for any government, whether it's a coalition government in Germany, whether it's a coalition government in India, or whether it's a coalition government anywhere in the world, that where parties cannot find the compromise that's needed, that those governments then are unable to pass budgets and unable to pass medium-term development plans. Sine, thanks very much for your question. Obviously, we want in the medium-term development plan to have our voice heard, and that is why we've been participating. It's why we've sent comprehensive inputs at every single stage of the process about areas where we think we can create jobs and grow the economy. Now, let me be clear. The clearinghouse is no substitute for the very important Section 19 that was included in the original statement of intent. The clearinghouse has got no clear terms of reference that have been adopted yet, and so it is a very strange way of trying to deal with a particular problem. We're happy to talk in whatever forums, but we are now invoking Section 19, which was specifically agreed to by all parties who signed the statement of intent. Let me be clear. Nobody was forced to sign the statement of intent. Every party, from the ANC to the DA to every one of the other 8 parties, signed that statement of intent. And in signing that, they bound themselves to Section 19 as a dispute resolution mechanism within the GNU. It's very clear now that despite the fact that the DA within government, through its minister, raised concerns, not only raised concerns, provided a very clear alternative pathway where we could end up with an expropriation bill that passed constitutional muster and which protected property rights and gave true effect to Section 25 of the Constitution and outlined what that process can be. Like the letter I sent on the NHI, it simply was brushed away. And that is not how partners treat each other. It's not, and no matter how many clearinghouses you have, that's not how you run a government. Leanne, as I said, I'm calling for a reset in the relations. Not saying that we're about to walk out the door, but I'm making an earnest, heartfelt, and conscientious appeal to the President, who got elected with votes from my party in the National Assembly, and who would not have got elected had the Democratic Alliance not made our votes available to him, to please listen to us, to take us into his confidence, and to allow us to play our role as full partners in this. We are not there to implement the NDR. We never signed up to the NDR. We never signed on a dotted line in the statement of intent that said the policies of this government will be the NDR. No, not at all. What the statement of intent said, that we would work to have evidence-based decision-making. It's very clear there. Nothing about the NHI is evidence-based. It exists today without even an understanding about what the budget implications of it are. So you're about to rush off and destroy an entire private medical sector in South Africa, to potentially destroy the entire healthcare ecosystem in South Africa, including the public healthcare ecosystem, when doctors start to leave in large droves, and we end up with great medical shortages, with very little evidence to show that it has worked. That's what we signed up for, evidence-based policy making, evidence-based decision making. And that is clear as black and white in the statement of intent, and that is how we intend to proceed if this government of national unity is to be a true government of national unity and not just simply an extension of the Sixth administration with some different faces sitting around the table. Thank you.
So now the answer to your question is yes. I have also raised my concerns in a 3-page letter to the President last year, but have received no feedback on that. Leanne, in terms of 7 and 8 verses 19, let me say the problem with 7 and 8 is that the expropriating authority could say that the value is nil, when that is not the true or fair or just or equitable value. And then it is up to the individual affected to then go and fight that themselves. And that in itself is not just and equitable. Whereas in Section 19 allows the individual affected, it allows for a structured mediation and negotiation process that involves the court to determine the just and equitable outcome. And so they are vastly different from one another. In fact, they are, I would dare to say, polar opposite. And for whatever reason, they thought it was wise to have two contradictory sequence of expropriation to take place. And that's why I'm saying it's not my opinion whether it's unconstitutional or not. It's by its very own obvious contradictions, it is unlawful and unconstitutional. And I'm not a lawyer, as many of you know, but I also know that in law you can't have two contradicting sections in a law, because what does the court do in that instance? And so this is now bound for court, just on that basis. So I think it's unfortunate. I think that an opportunity was missed to rectify it, and I would just leave it at that. Thanks.
Thank you, John. Thank you, Dean. Let's have a second round of questions. 1, 2, 3. Let's start here with you.
Abongwe Kobokana from the SABC Radio News. The leader of the FF Plus, Dr. Peter Groenewald, yesterday told us that he will be writing letters inviting some various political parties in Parliament to actually refer the Expropriation Act to the Constitutional Court to determine its constitutionality. Will you then accept that invite if then you are approached by the FF Plus? Thank you.
Thank you very much.
Good afternoon, Llewellyn Prince of Netwerk 24. My question is directed to the Minister, McPherson. Just in terms of, I heard the DA declaring a dispute with regard to this expropriation bill, and also the fact that you also have concerns and have a legal opinion that the bill is unconstitutional, but the President has signed the bill. And you as the Minister and your department as the implementing department have to implement the bill. So where does it leave the bill itself at this stage? Are you going to implement? Are you going to take it to court? Or what is the next step with regard to the bill, because it has been signed now? Thank you.
Thank you very much. Last one for this round here.
My colleague from the SABC touched on the unlawfulness and the fact that the Act is not, the Land Expropriation Act, in the DA's opinion and other political parties, is not constitutional. how soon can we see papers being filed in the Constitutional Court?
Thank you very much. Was that question directed to John, or I'll direct that to John? Okay. Thank you very much. So we've got Bongwe, Llewellyn, and Aisha. John, if you can take over there, thank you.
Thank you very, very much for that. We'll support any process that leads to the constitutional determination of this bill. However, I don't think that we need to go through those processes. I think we can approach the Constitutional Court through the legal processes there in order to that, but we will work together with all parties. And I think it's instructive in the question that you ask that yet another party outside of the DA and the IFP are unhappy about the way this has unfolded. And had we been able to have the opportunity to sit around as leaders of these political parties and have a conversation about this, instead of having the conversation with you today, I think it would have been a much healthier way to resolve the matter. And I think we could have found a way forward. But what we are seeing is a government that is just continuing to carry on as if nothing changed in the election of last year. And that cannot be right. That now certainly three of your larger coalition partners are aggrieved that they now have to seek other mechanisms to deal with it outside of a mature adult conversation between the leaders of the party shows that there's clearly something wrong. In terms of the papers, please forgive me. I've landed 2 hours ago from Davos. Helen Ziller, as you know, as the chairperson of the Federal Executive, handles legal matters. And there are several briefings, I'm sure, that, as you're aware of, that I'm awaiting since my landing here. And obviously, once that process is clearly defined, we'll be able to release that to the media. But I can just tell you this, from our side, this situation, this bill will not stand. And we will not stand to watch this type of legislation being passed, not on our watch and not while we are part of government. And whatever mechanisms we have, both legal and political, to resolve this situation, we will do so. I think I've dealt with those here.
Thank you, John. I can just, on that question with regards to the legal papers, I understand John only landed at 10 o'clock this morning. I wish it was 10. Was it later? I can confirm that the Democratic Alliance gave instructions to our lawyers, who have also provided us with a legal opinion on this, and have clearly stated to us that this act is not mustering constitutionality, and they are in conjunction with us drafting the papers to test the constitutionality of this. The Democratic Alliance made it very clear that we will do everything in our power to fight this, and going to court is one of those steps. Dean, I'm going to hand over to you to answer Llewellyn's question. Thank you very much.
Thanks, Llewellyn. Well, I think that now that a formal dispute has been declared in terms of the statement of intent, I'll have to be guided by the parties now in the GNU on what the next step is. But what I would say is, I see the Deputy President of the ANC did an interview today saying that if I'm not going to implement the bill, then I should resign. There's only one person who will tell me to resign from government, and that is the leader of this party. No other leader or no other member of another political party will tell me when or how I should resign. And it is that sort of arrogance that I think is unhelpful in the GNU, and I think makes for unpleasant sort of encounters with one another. We are all here to do a job. We all have views on the job. I don't give my views on the Deputy President's performance or lack of performance. I keep that to myself. And I think that other colleagues should probably consider that as well when they put on their political T-shirts and cast their views on what one another should do.
Thank you very much, Dean. Let's have a third round of questions. Can I have a hand? Paul there at the back again.
Hi, Paul Becchiato from Bloomberg again. Dean, does this situation put you in a bit of a bind as a minister? Because on the one hand, you have to kind of enforce what the president's signed off, but on the other hand, your party is quite opposed to it. How are you going to navigate this? Are you going to enforce this act or not?
Thank you very much, Paul. Any other questions? Yes?
My name is...
Sorry, just wait for the mic.
My name is Thabo Mugoni. I work for the Sunday Times. John, with the dispute that you've just declared now, are you then saying that as far as you are concerned, the implementation of the Act should be put on hold until this dispute is settled? Is that my correct understanding?
Thank you very much. Any other questions? It seems then that for now, there's another one here. Thank you very much. Sorry, just wait for the mic for a second. There you go, if you can take the mic.
I'm Melika Zakagana from Eyewitness News. I'm sure that it has reached your ears that yesterday, SAPS launched an investigation on 2 MMCs at the city of Cape Town. Will there be any reaction today on that?
Okay, thank you very much. I'm going to give to Dean just first to quickly answer Paul's question and then to John.
I think, Paul, let me say again that a dispute has been declared, and I await further guidance now from the parties that are actually signatories to the statement of intent, because it's not just the DA that has a problem with this. There's at least 2 other parties and maybe another one that has a problem with this. So I think that it requires political guidance. And so we will go from there. Thanks.
Thank you, Vili, and thanks a lot. We've declared a dispute now, and Thabo, and it'll be up to the parties, the leaders of the parties now, to decide how we go forward. And that's kind of what I'm asking for today, is that let's talk about these things before decisions are made. If we had been able to get into a room and have a discussion about this, the president had said, look, I've heard your concerns from your guys' side, but these are my reasons for proceeding. Perhaps we could be in a different place today. But the first I heard about this bill being signed was on social media when somebody showed me a tweet that had gone out. And I don't think that's how we treat our fellow partners in this great project of ours, of the GNU. And so it'll be up to those leaders. I'm not going to prescribe to them right on this podium how it should proceed, but I'm saying, Mr. President, we need to talk, and we need to find a better way of ensuring that we give true effect to what the voters wanted from the 7th administration, which was change and a new way of doing things. Thank you very much for your question from EWN. Yes, I was alerted yesterday evening in transit back from Davos whilst in London, and I was sent a very brief message from Mayor Hill Lewis that the Hawks had undertaken raids at Alderman J.P. Smith and Alderman Xanthia Limburg's office yesterday. The Mayor informed me that he has asked for a full briefing from the SAPS on what the nature of the raid was for and what the nature of the investigation is about. Once he has received that, he'll be able to brief me more fully, and we'll be able to make a more definitive statement going forward. I will, however, say this, that wherever instances of wrongdoing that involve DA public representatives have been raised, once it has reached the substantive phase and there is prima facie evidence of wrongdoing, the DA has moved, in all cases, to suspend and in many cases remove those public representatives. And I want to assure you that within this matter, once the facts have emerged, once the prima facie evidence is on the table, we will have a more determined way about how we proceed going forward. At the moment, it remains speculation. But it is a matter which I'm certainly watching closely, and it's a matter which the party will deal with incredibly seriously and diligently, as we have always done in cases of this matter. Thank you.
Thank you very much, John. Colleagues, that brings us to the end of the question session. I just want to say the following. It is very clear, if we look at the determination of which the DA ministers are bringing to the table within this cabinet, it is clear that we are here to rescue South Africa. Everything that we do within this government of national unity and as a party in committees in Parliament is based on two things. Will this grow the economy, and will this lower the unemployment rate? We've got to grow the economy and got to create jobs. The signing of this bill is definitely not a step into that direction. It's definitely jeopardizing the trust to South Africa out there from foreign investors. We've got to turn South Africa around, and we've got to keep on doing the right thing. Thank you very much, John. Thank you very much, Dean. This then brings us to the end of this press briefing. Thank you very much, colleagues.